Welcome to the NPERS Estate Planning Seminar. My name is Ramzi Hynek. I'm a partner attorney at the law firm of Rembolt, Ludtke, located in Lincoln, Nebraska. We do have another small office in Seward, but our main office is located downtown Lincoln. Again, I am Ramzi Hynek, and my area of practice is primarily estate planning and probate. I do a little bit of real estate work, some guardianship, conservatorship work, and a little bit of Medicaid. So we will not be able to touch on every single one of those topics today, but you'll be surprised we're going to hit quite a few of them. So let's just go ahead and dive in and get started today. And we're going to start with the very basic topic of what is estate planning. Estate planning means different things to different people. Probably when you hear the term estate planning, the first thing that comes to your mind is a will, and that's very fair. That is the most common and basic estate planning tool that we use. But as you'll see today, that there are other tools. And to me, as an estate planning attorney, the topic of estate planning is much more broad than just a will. It's really more than just who do you choose to leave your assets to upon a death. So for example, when someone may come to meet with me as an estate planning attorney, we may have a conversation about a family business, for example. Is there a transition plan in place? Have you had a conversation with your children? Does anybody want to come take over that business? For example, I grew up on a family ranch up by Valentine, Nebraska. And at one point, there was a conversation with my family as to whether or not my brother and I were going to return home. That gave a lot of knowledge to my parents and the freedom to make their own plans, but it also kind of set a tone of expectation for my brother and I for planning our own lives. So when I meet with families on that, we're not only talking about the transition of the assets of the family business, but I also like to look at it from, is there any knowledge that can be passed down? For an example, we will sometimes set up a family business in an entity structure where maybe we bring the children in as minority shareholders. And the concept behind that is to get them involved and maybe just get them interested enough that they start paying attention. And they start learning some of those lessons from watching mom or dad run a business that they can incorporate it into their own life. So again, it's not just passing assets, but our goal is also, if available, we'll also pass some knowledge, hopefully. As another part of that initial estate planning meeting, we might talk about things like insurance. Do you have enough? Do you have too much? Our job as an estate planning attorney is not to sell insurance products by any means, but we definitely can help you to identify what your needs are, and then you can go talk to that insurance professional. In that initial estate planning meeting, it's also very important that you be open and honest with your estate planning attorney about your particular family dynamics. So the types of things that you need to talk about in that initial meeting are things like who gets along, who's the troublemaker of the family, who's the peacemaker of the family. So we can help you to best identify the people to fill different roles. So family dynamics. We also, it's helpful if your estate planning attorney is also aware of things like, is there a child that you're fearful may go through a divorce one day? Is there a child who's very poor with money management? There are potential solutions to all kinds of issues such as that, but if you don't share those issues with your estate planning attorney, your attorney doesn't know what options to present to you. So it doesn't mean that you always have to go with the most complicated or most expensive option presented, but when you're shopping, shouldn't you understand your options and you can make an informed choice? So don't hold back information. Anything you tell your attorney is confidential, and your attorney can't and will not share that with anyone else. So back to estate planning as a general concept. It means different things to different people, but there are some common goals within estate planning. One of the most common goals that we see is planning for taxes, and taxes particularly upon a death. it is a common goal of estate planning attorneys to help you to minimize those taxes upon a death. And that is also a reason people will often seek out estate planning counsel. Another common goal of initiating estate planning is to plan for minor children. Both a selection of a guardian for your minor children, but also maybe making a plan for assets of your children should you leave any money to them upon your passing. I have 2 young kids, and I have no idea what they're going to be like when they grow up, but I know one thing: I'm not going to trust them with money when they turn age 19, which is the age of majority. Children at that age, in my opinion, are far too subject to bad influences and are not ready to make proper decisions. And so it is a very, very easy thing to do to put money into a trust for minor children. Another obvious common goal of estate planning is to pass assets to children or loved ones in the manner that you desire. Equal doesn't always mean equal, but it is certainly something to be considered. What are your goals and how can they best be obtained for each one of those beneficiaries? And finally, a common goal of estate planning is probate avoidance. Now, throughout this presentation today, I am going to be talking about probate an awful lot. So just as a heads up, I want to give you an upfront working definition of probate. Probate is a court proceeding. Some estates are required to go through probate, and some are able to avoid it. Now, I don't want to scare you. Probate is not the end of the world as far as a court proceeding is concerned. We help families go through it all the time. It is a very organized, logical process. But probate, again, is a court proceeding, which right away probably tells you you're going to have a lawyer involved, which is going to result in more cost. A couple of the other drawbacks to probate are it takes more time typically to go through a probate proceeding. It is a public proceeding as well, so some people are concerned about others' ability to look in on the process. And it generally leaves more work behind. You know, as we're talking about goals of estate planning, probably the most common goal that my clients tell me that they have upon a death, my goal is to minimize the amount of work that I'm leaving behind for my loved ones to complete when I'm gone. When I hear a client say that, what I know that they really are meaning, without maybe not knowing it, is their goal is to avoid probate. Probate avoidance is one thing that you can do to minimize. You're not going to ever get rid of all the work, but you can certainly help to minimize the amount of work that you're leaving behind. On the next slide of your presentation, you will see a short statement that helps to summarize a typical client's expectation or goals of estate planning. I want to control my property while I am alive, take care of me and my loved ones if I become disabled, and when I die, I want to give what I have to who I want, the way I want, and when I want, and if I can, I want to save every last tax dollar, professional fee, and court cost possible. I think that does a good job of summarizing a typical client's goals, and all of those goals are achievable in almost every circumstance. Again, just be open to the process with your attorney and be open to hearing different options so that you can make an informed decision for what's right for you and your family. So why have an estate plan? That is a very common question that I get as an estate planning attorney. And the typical person that's asking it is not a multimillionaire. They're just the average Joe or Jane, and they say, I don't have millions in the bank. Why do I need a will? Why do I need an estate plan? Well, there are many answers that I could give, but one common thing that I answer is, would you leave $20 on the street for anybody to come up and find? Probably not. So why would you take that gamble with all of the hard hard-earned dollars that you've saved during your life upon your death. Take control, make decisions, make informed decisions, and those wishes can be carried out when you're gone. So you may not realize this, but if you are a resident of this state of Nebraska and you are over the age of 19, if you have not prepared a will or a trust, an estate plan for yourself, the state of Nebraska has drafted one for you. There are laws in Nebraska known as laws of intestacy that determine who upon your death will receive your property upon your death if you have not otherwise made provisions for who's to receive those assets. Now, those laws are something you may just now be learning about. So again, why would you trust and rely upon a law to determine who's going to benefit from your estate upon your death? Why would you ever do that? Take control, take ownership of who you truly would like to benefit. Under those laws of intestacy in the state of Nebraska, most people may assume that everything would go to the surviving spouse, and that is not always the case. The laws of intestacy in Nebraska look at several factors. They look to see, is there a surviving spouse? Are there surviving children? Are those children the children of the surviving spouse? And from there, they also take into consideration, are there surviving parents or other relatives? And long story short, even in the quote stereotypical family dynamic of one spouse, two children, both children belong to that surviving spouse is not going to get everything. In that example, the surviving spouse will get the first $100,000 and half of everything else. Now, I'm oversimplifying here, but the point I'm trying to make is do not assume everything will go the way that you intend. So again, take control, take ownership, and just at least do the bare minimum of putting together a will or a basic estate plan. So again, why should you have an estate plan? We want to avoid the laws of intestacy, but we also want you to provide for any minor children. We've already discussed this today, but remember, you have the opportunity to nominate someone or persons to serve as a guardian and conservator for your children should something happen to you. But it's also a good idea to plan for management of any funds that you may be leaving to a young person. Also, in the case of a second marriage, we find that a really important time to reconsider your estate plans and put something together. I'll just give you a common example. The husband and wife come into my office. It's a second marriage for each one of them, let's say. And for purposes of this example, let's assume that both have grown children that are not dependent or reliant upon them for funding and assets. So in that example, it's really common for the husband and wife to say, we've discussed, we've agreed upon the first death, we're just going to leave everything to each other. And we've agreed on the second death, everything will be split equally amongst our children. I've seen that work. But you know what else I've seen? I've seen the surviving spouse change the will the day after the first spouse's funeral. If you leave everything to a surviving spouse, it's theirs. It is their money, and they can do anything with that money that they may choose to do. So one common solution to that situation, and this is only one example, is perhaps each of those spouses, instead of just doing a simple will, do what we call a trust. And in this example, perhaps the spouse could leave everything in trust for the benefit of the surviving spouse. In that way, we meet the goal of meeting the needs of that surviving spouse, but that trust can also state whatever is not needed by that surviving spouse. When that second spouse passes away, I get to control, or the trust document will control where the rest of the funds are to go. So you can be sure that your children will be provided for, or your favorite charitable cause, for example. Another reason to do estate planning, as we discussed earlier, is to do tax planning to minimize the amount of tax that your estate may owe upon your death. And finally, if you're charitably inclined, you absolutely need to do an estate plan to make sure that those special causes to you are considered and would receive something from your estate. Those laws of intestacy in the state of Nebraska do not provide anything for your favorite charitable causes. So there are 3 typical steps of estate planning. The first step we won't spend much time on today, because that step is working with an attorney to draft and prepare and sign either a will, perhaps a trust in combination with a will. But that attorney that you select is going to hold your hand through that process. Just find a good attorney that you feel that you can have a good conversation with, that they are going to hear your goals and provide you with a document that actually meets those goals, and they will guide you through that process. So today, I think it would be better if we focus our attention to what I have marked as step number 2. Step number 2 is, how do you title and who do you list as beneficiaries on your assets? Step number 2 is just as important as the drafting and signing of a will. In fact, in many ways, it could be perceived as being even more important, because the title or ownership of your asset trumps whatever your will says. Same thing with beneficiary designations. Beneficiary designations, if they're included on an asset, trump whatever that will says or whatever that trust may say. So I'll just give you a quick example on that. Let's say you listed your children as the beneficiary on a life insurance policy, but you subsequently got married, and then you created a will that left everything to your new spouse. Under that example, the default rule is going to be the beneficiary designation controls. And so the children in that example would be the beneficiary of that asset. Now, again, I'm greatly oversimplifying, but the concept holds true. The beneficiary designations and title, meaning ownership of the asset, trumps the will. Now, when I mention title, one common ownership or form of title that you may hear of is joint ownership. Sometimes it's called joint with rights of survivorship, or abbreviated as JTWROS. What that means is we have at least 2 owners of that asset. And if one owner passes away, the surviving owner is the owner of the entirety of that asset. It automatically passes to the survivor. Compare that with what's known as tenants in common. And if one owner passes away, the ownership doesn't automatically go to the survivor, but instead the ownership of that asset will pass through the estate plan of the person who passed away. So it is very important to review the title of all of your assets. Unfortunately, I have found in several situations where a husband and wife believe that they own their house joint with rights of survivorship, but when I actually pull up the deed, it turns out they actually own it as tenants in common, which does not meet the goal that they have for that particular asset. So it is not good enough just to look at the assessor's website of your county to determine ownership. You must go beyond that, and you actually must look at the deed itself. It must say joint with rights of survivorship if that is your goal, because the default rule in Nebraska is that title is held as tenants in common. So some assets will pass based upon your will. However, as we've been discussing today, many of your assets will pass based upon how you title your assets and if you have added a beneficiary designation. So as we have been discussing today, some assets will pass through or by the terms of your will and or trust, and some will pass based upon title and or beneficiary designation. Now, at the beginning of this presentation, I mentioned to you we're going to talk about probate an awful lot today. Well, here's our first discussion on probate. So here's your will. My hand is your will. The will is what's filed for probate. Anything that passes through and by the terms of your will to go out to your loved ones passes through the probate process. But I said only things that pass through the will. So if you have a house, for example, that is titled jointly with your spouse, your will is not going to control who owns that house upon your death. That's going to pass based upon the title that you've established. It's going to bypass the will and go directly to that surviving spouse in that example. The same thing holds true if you have a beneficiary designation on an asset. So again, here's your will, and let's again use that life insurance policy. And let's say you have a beneficiary designation named on that life insurance policy. Your will is not going to control who receives the proceeds from that life insurance policy. It's going to bypass that will, and it's going to go directly to your named beneficiary. So anything that is bypassing the will is avoiding what's known as the probate process, the court proceeding known as probate. Your will, however, determine who receives assets that are just in your name, no other owner with you, and no named beneficiary. I suppose the other way that probate can be avoided on an asset, again, here's your will, is if you also have what we call a living trust or a revocable trust, and you title assets into the name of that trust, so your trust owns that. In that situation, again, it's going to bypass the will, and it is going to be going to your selected individuals directly and not going through the court process known as probate. So that is how some individuals are choosing, under current methods that are available to us to avoid probate, is let's go add beneficiary designations to everything. Now, that is not the right plan for everybody, but it is definitely one option that you may choose to discuss with your attorney. Did you know that you can add beneficiary designations to nearly everything that you own? You probably already know that you can add beneficiary designations to things like life insurance, retirement accounts, but you can also add beneficiary designations to checking accounts, savings accounts, any sort of investment account like a brokerage fund, mutual fund, CDs. You can add beneficiary designations to all of those assets. You can also add beneficiary designations to vehicles, to automobiles. You do that down at the DMV, and they will actually put that beneficiary designation right on the vehicle title itself. And finally, the one category I haven't mentioned yet, real estate. In the state of Nebraska, we have passed legislation that now allows us to add beneficiary designations to any real estate that we own. We do that by preparing and recording what's known as a transfer on death deed. You might hear it called a TOD deed. It may sound more intimidating than it is, but long story short, you remain the owner of that piece of real estate. Let's say it's a home. You're the sole owner of that home. You have all of the control over that home. You can sell it whenever you want. You can mortgage it whenever you want. But if you have that TOD beneficiary added, it says, if I die and I still own that piece of real estate, then whoever you named becomes the new automatic owner. It's very easy. All they have to do is record your death certificate and they're done. So within a week or two of your passing, for example, your children could be the owners of your home and they could rightfully list it for sale if that's what's appropriate in your situation. A couple questions I get on transfer on death deeds, because this is a newer concept in Nebraska, is can I own, I own my real estate jointly. Can I add a beneficiary designation to jointly owned real estate? And the answer is yes, you absolutely can. Can you name more than one beneficiary? Yes, you absolutely can. And you can also name contingent beneficiaries. So I name these individuals, but if neither of them survive, then here's my list of contingencies. It's also important to know that you can revoke those beneficiary designations at any time on a transfer on death deed. So step 3 to estate planning that is on the slide in front of you is to review. I encourage you to review your estate plan, the title, and beneficiary designations you have on your assets regularly. In a perfect world, I'd tell you to do it every year. But for my clients, for example, I send a letter out to them every 3 years just as a reminder that it's a good time to take a look. It doesn't mean you need to reach out to your lawyer every 3 years, but it's a good idea to review the document to make sure the people that you have selected in that document are still the appropriate people. And finally, we encourage our clients to use what we call a team approach. Your lawyer is only one member of that team. Perhaps you have a financial advisor or an insurance agent, or you just have a darn good friend who's really smart at these types of things. Make sure all of those members of your team are on the same page and communicating enough that they're not accidentally leading you down different paths. So there are several options for your estate plans. The first one we've already discussed, and that is called intestacy. That's one we generally like to avoid. With intestacy, again, that means you did not prepare an estate plan for yourself, and so the default laws, known as laws of intestacy in Nebraska, will kick in. This may sound like a good, cheap option, but in the end, trust me, it actually will end up costing your family likely more money, but almost certainly more time and effort to wrap up your final affairs when you're gone. So not a good option. A better option, and an option that's appropriate for most individuals in Nebraska, is just what I call a simple will. And I'm using that term pretty loosely because a simple will doesn't have to be simple. It can be as simple as what I call the I love you will, honey, I love you, I'm leaving you everything, to something much more complicated like I will leave 10% to this individual, 90% to this individual, and it could also, under the way that I'm referring to this, it could also in this category include what we call a simple will that creates a testamentary trust for minor children. Now that's a mouthful, but to be honest, all it means is I'm leaving a will that says if I pass away, then a trust is to be created. It doesn't exist today, it's only created upon my death, and it's often used for minor children. So if I should pass away and I want to leave money to minor children, then it can be left in a trust so that I can put restrictions on it so that they receive the money at appropriate times. A common way to structure that is to say, we have a trustee in place who's going to be managing the assets and making appropriate distributions as they think is appropriate. But perhaps it says at age 25, 1/3 of that child's interest will be distributed out to them free of trust. At age 30, they'll get half of whatever's left at that time. And finally, at 35, they get the remainder. Now, those ages are something that you can modify, but that's kind of a good starting point to think about. So long story short, you can very easily set up an estate plan that says everything to my spouse, but if we're both gone, then a trust is created for our minor children, and I've appointed someone to manage those assets, and I know at what ages they're going to receive those distributions. So again, most people can meet their needs with what I'm referring to today as a simple will. One good thing about a simple will is it's very easy. All you need to do is, again, find that good estate planning attorney that you feel comfortable with, and they're going to draft it for you. Your job is to give them the information, identify your goals for them. A cost estimate for a simple will, it can vary. I've seen it anywhere from, say, maybe $300 to $800 perhaps, and it will largely depend upon what your goals are and what you're trying to accomplish. Within that fee quote, you will often also be receiving what we'll discuss later that are known as power of attorney documents. Within your simple will, if you have one, I would highly encourage you to go look for language that sounds something similar to this. I may leave behind a written list or memorandum that specifies who is to receive my household goods and personal property. Again, I want you to go home and look at that if you have a will. That is what I call a laundry list provision. And this is a wonderful thing. If that language is in your will, what that allows you to do is on your own time, after you've left the lawyer's office, take out a piece of paper and create a list of items that you want to go to certain people. This is not required, but I really, really encourage clients to consider doing this. Most of my clients don't think that they have anything of financial value, but from my experience, I know everybody has something of sentimental value, and you very well may be surprised what someone may hold dear. And it also is a very helpful tool to help to minimize or possibly avoid some nasty family fights. You see the most crazy examples happen out there, people fighting over the ugly Afghan on the back of the couch. We've seen some family relationships that will never be repaired over just simple items of household property. So if you, again, have that magic language in your will, that allows you to leave one of these lists behind. One of these laundry lists can be amended by you at any time. You don't need to go visit your lawyer's office. All you need to do is draw it up, and it has to be signed and dated by you. No notary is needed, no witness is needed, and you can tear it up and start over at any point. Just do not cross through any initial changes. Start over. That's very important. So another option for estate planning is to do what we call a living trust. Sometimes you'll often hear it referred to as a revocable trust. So if you choose this option, you're still going to have a will, but the meat of your estate plan is really going to be in this trust. A trust can be a harder concept to get your mind wrapped around, but it is a document that you're creating something that's in existence today. You can actually take ownership of an asset, like a piece of real estate, and have your trust own it. That doesn't mean you're giving it away. That doesn't mean you don't retain control and authority, but it is often set up in a way where your trust will actually be the legal owner of that piece of real estate. Most people don't have a need to create a trust such as this, but there are some common reasons why people consider doing so. One reason is to avoid probate. Now, I already discussed with you today, there are other methods now available to avoid probate, such as adding beneficiary designations or titling your assets in a certain way. But a trust does remain a very good option, tried and true option of avoiding probate if that's a goal of yours. But the more common reason, or another common reason that people may choose to do a trust is to minimize taxes upon a death. So if you have a large estate plan, trusts are often the tool that we're using to do some of that more sophisticated planning. And finally, people may choose to do a trust in the case of a complicated family situation. Earlier, we talked about a second marriage. That's an example of where a trust may come in handy. But long story short, you can use a trust to accomplish almost any goal. We've helped clients create trusts for the benefit of animals, situations where there's just a difficult family situation where it's not appropriate to give money in a large sum to any one person. Maybe you want it available to care for them, but you want to make sure that the remainder of it is going to be there for the next generation. Sometimes we've done what are called incentive trusts, where we will put in provisions that say, just to give you an example, I will give you as much out of this trust as you show in your W-2 tax statement for the year. So if you're working, this trust will work for you. You can incentivize people to do certain things. Not as common, but basically if you can dream it up, chances are there's an option available for you in a trust. So you may be sitting there wondering at this point, when is she ever going to tell me what type of estate plan is right for me? Can I just do a simple will, or am I in need of a trust? Unfortunately, that is not something that I can answer for you today. You are going to have to go meet with your own legal counsel to go over your particular facts and family situation to identify your goals and your needs. But again, just to summarize, why do people typically do a trust? One reason is to do tax planning. A second reason is perhaps to avoid probate. And a third reason is to take care of some of those more complicated family situations. Now let's turn to the topic of tax, everybody's favorite subject. The first type of tax that we need to think about upon a death is the federal estate tax. This is the big one. This is the one that no one wants to incur. So the way that this one is calculated is we look at what's known as your gross estate. Long story short, we add up everything that you own and we put it into one big total. For the federal estate tax, that actually will include any proceeds from life insurance. So everything is added up. You are able to pass any amount to your spouse that you want tax-free. Same thing goes for charity. That's all tax-free as well. Beyond there, you are able to pass a certain amount tax-free. Each one of us have a certain amount available to us. In the year 2020, that magic number right now is $11,580,000. So if you're listening to this and you're under that number, then you're probably safe. Now, here's the catch though. That is subject to change. And I'm going to give you a very quick history lesson to explain why. Starting back in about 2001, there was a debate within Congress as to should we be taxing estates upon a death or not. And surprise, surprise, they couldn't agree. So they made a compromise and it put in a 10-year plan into place. And basically what that did is it gradually increased that number. And in 2010, that number actually expired altogether. And in 2010, there was no federal estate tax. It was a great year to die. But in the next year, 2011, what they did, they reached a compromise, a temporary plan, and they kept increasing that figure. Long story short, where we are right now, as I sit here today, the magic number that any one of us can pass upon death is $11.58 million. What you should know about that, though, is that is a part of the Trump tax bill that is set to sunset in 2025. And it's subject to the whims of Congress, so they can change it at any given point in time. I don't have a crystal ball, so I have no idea what's going to happen. But if that should sunset, my best guess and expectation is that it will come back down, and with inflation, we're still going to be somewhere around $6 million a person that we're able to pass tax-free. Now, also remember, with some careful planning, if you have a husband and you have a wife or two spouses, With some careful planning, you can actually make use of both of those persons' available credit upon death, and you can double that figure. Why people are so worried about the federal estate tax is once your estate is larger than that magic number, let's say right now 11.58 million, anything that you own in addition to that number is taxed at 40%. So almost half of anything above that is going to go away to Uncle Sam. So that's why we pay particular attention to that tax. Now, we also need to think about the taxation of your particular state. Some good news, first of all, is in the state of Nebraska, Nebraska has repealed its estate tax. But before you get too excited, Nebraska does still have what's known as inheritance tax. Now, the federal estate tax that's paid to the federal government, that is essentially taxing your ability to give away your property upon death, versus the inheritance tax that's really looking at the beneficiaries receiving that property. So it's just a different perspective that Nebraska has chosen to take on this tax. Again, it's based upon your gross estate. Everything that you own, we add up. But the public policy of Nebraska is that we are not going to tax the proceeds of life insurance, so long as you've named a beneficiary other than your own estate. Don't list your own estate as the beneficiary. So we add up everything that you own, and we start to look to see who's going to benefit from that money to determine the amount of tax that's owed. Anything that you leave to a spouse or to charity, that's tax-free. From there, we categorize everybody into 3 classes of beneficiaries. Class 1 beneficiaries include your children, your grandchildren, your parents, your grandparents, your brothers and sisters, and spouses of anybody within that group. Each one of those individuals will get the first $40,000 tax-free. Now, anything they get above that $40,000 is taxed at just 1%. So not the end of the world, but it does take some work to calculate, and it must be accurately reported and filed with the court for approval before payment. Now, Class 2 beneficiaries are your family members, but further related. So that would include people like your cousins, nieces, nephews, aunts, and uncles. Each one of those individuals get the first $15,000 tax-free, and that tax rate jumps up to 13%. So that is a much more significant hit. Class 3 individuals are your non-relatives, so that best friend that you're choosing to benefit, or that significant other that you have chosen not to marry. Those individuals only get $10,000 tax-free, and that tax rate jumps up to 18%. So my suggestion is, if you want to benefit somebody, don't always let the tax tail wag the dog, but it is definitely a consideration that you should make before leaving a significant gift to a non-family member. The last type of tax I think we should discuss today is gift tax. So gift tax is again a federal tax, but this one is not upon death. This is actually during your life. The good news is that each one of us are able to give away up to $15,000 per year per person. So I could, if I chose, give every person who watches this video $15,000 this year and next year and every subsequent year of our lives, but neither one of us would have to report that for gift tax purposes. Well, let's say instead of $15,000, I gave you $20,000 in this 1 year. The first $15,000 is ignored, but there is an extra $5,000 there. So that puts the responsibility upon me, the generous person, to file a gift tax return. You, the person who received that gift, have no obligation of reporting that. That is not income that's reported to you. So I file a gift tax return. Now, the good news for me is that in my situation, I'm still not going to have to pay tax. And that's because each one of us have what's called a lifetime gift tax exemption. And right now, that is $11.58 million. So while I have to report that gift as a potentially taxable gift, the IRS, from my reportings, will keep track of how much of that $11 million have I used up making gifts during my life. And it's not until I run out of that exemption that I would actually incur gift tax. Now, one important thing to keep in mind is any part of my $11 million that I use up making gifts during life reduces that $11 million that I have available to give away upon death. So do some careful planning, but long story short, most of us can give away everything we own without paying taxes. Now let's turn to the topic of probate, which is the conversation that we've been having periodically. Just as a quick review, probate is a court proceeding that some estates have to go through after a death and others are able to avoid it. Again, it's well thought out, it's organized, but many people choose to try to avoid that process. So again, as a basic summary of what we discussed earlier, here's your will. All assets are subject to probate that are flowing through the will, except if you own something jointly, it bypasses the will, so no probate. You have a beneficiary designation, no probate. And third, if you have a trust and your trust owns an asset, then no probate on that asset as well. You may see on the topic of beneficiary designation some initials that are POD or TOD. Those stand for pay on death or transfer on death. Whenever you see those initials, just know that that's a shorthand way of saying beneficiary designation. And for purposes of this discussion, you really don't need to know the difference. So again, some considerations with, is it worth it to you to try to avoid probate? One consideration is confidentiality. It is a public proceeding. Your nosy neighbor can go see what you own and who you gave it to, but for most individuals, it's probably not a big concern. So the more significant factors that I encourage you to think about are the time involved in administering a probate. In Nebraska, a probate must remain open for at least 5 months, but I would say it typically takes more along the lines of 6 months to a year to complete. And also consider cost. It's expensive. There's no way around it. Some attorneys, especially in Western Nebraska, choose to charge a fee based upon a percentage of the estate. In Lincoln and Omaha, you will more typically see fees charged based more upon an hourly rate. There's not a right or wrong, but it's okay to ask, and it's a good idea to get an understanding up front of how that fee will be earned by the attorney. As a last consideration on probate, I want to discuss briefly what's known as ancillary probate. We really want to avoid this. This means you have not one probate proceeding, but two. Where an ancillary proceeding can occur is when you die a resident of Nebraska, but perhaps you've purchased that condo in Colorado for skiing. So the drawback of an ancillary probate is not only may you have to go through a probate proceeding here in Nebraska, but your loved ones may also have to open a second ancillary probate proceeding in the state of Colorado, likely hire separate legal counsel, incur additional fees, because the state of Nebraska does not have jurisdiction to administer real estate in another state. Now, I want to emphasize I'm really only concerned about real estate in this situation, but if you find yourself in that factual scenario of being a Nebraska resident, owning out-of-state real estate, then you definitely should do some planning with the help of your legal counsel. So for our final topic today, I would like to discuss what are known as power of attorney documents. These are documents that help you to identify someone to step in and make decisions for you in the event that you're unable to do so for yourself. It may be a situation where You perhaps have Alzheimer's, or perhaps you've been in an injury, a traumatic event like a car accident, and you're unconscious. So these documents allow you to pick a person known as an agent to step into your shoes and make those decisions for you. But before I get into talking about those decisions, let's first think about what happens if you don't have these documents in place and you haven't picked a person to make those kinds of decisions for you. The option available at that time is what's known as a guardianship and conservatorship, which is a court appointment. Now again, this is not the end of the world, but it is definitely something that can be avoided and definitely something that most individuals would choose to try to avoid. First and foremost, because you are not the one taking control and making the best selection for yourself. The court in that scenario of a guardianship and conservatorship is stepping in and evaluating those that are stepping forward and trying to look into your best interests for you. A guardianship and conservatorship can be expensive, it takes time, and honestly, it creates an awful lot of work for someone that you love that could be avoided simply by doing these power of attorney documents. So everyone should do them. If you are a legal adult in the state of Nebraska and mentally competent, you should have them. It doesn't matter that you're married. A spouse has no legal authority to make financial decisions for you, and also does not have legal authority to make healthcare decisions for you. So again, take charge, do the simple, responsible thing of at least doing power of attorney documents. The first type of a power of attorney document that each one of us should have is what's known as a general durable power of attorney. This is for financial decisions. Typically, this is written in Nebraska so that it's effective immediately. So even though you're fully capable and competent, your agent can step in and make decisions for you today. The reason we draft it this way is so that your agent doesn't have to prove every time they go to pay a bill on your behalf that you're still in a coma. So we just encourage our clients to pick people that you trust, regardless of your situation, so that they're ready at a moment's notice to step in as necessary. By signing this document, you're not giving up any control or authority. You remain fully in charge, and your agent is only authorized to act to the extent that you want them to be working for you or on behalf of you, or if you can't, should that event occur. The second type of power of attorney document that I feel that everybody should have is what's known as a healthcare power of attorney. This is, again, exactly what it sounds like. You're picking a person to make medical decisions for you in the event you can't do so for yourself. As compared to the financial power of attorney, this one is typically drafted in a way that it's only effective should you need it, only effective if you can't make your own healthcare decisions. For both of these documents, I highly encourage you to pick not just your first choice, but let's pick choice number 2 as your backup, and maybe even a third just to be extra safe and make your document last that much longer. Some people think about geography as a factor. That may be more appropriate for a healthcare power of attorney as a factor to consider. But bottom line, think about who do you trust? Who's going to be respecting your wishes as you've communicated them? And who's going to be a good communicator to the rest of the family and the rest of the people that you love? So most importantly, keep in mind, this is not an honor that you're bestowing upon somebody. You're actually asking someone to take on a very serious job that can be a big time commitment. So try not to worry about offending anybody. And remember, in the end, they'd probably be fighting as to who doesn't have to do it. Not me is what rings through my mind when I think about that conversation. In the realm of healthcare documents, you're going to hear lots of terminology. One term that you may hear is advance directives. Do you have an advance directive? That is a generic term for all sorts of healthcare documents. One type of an advance directive is what we just discussed, a healthcare power of attorney. In my opinion, that's the most important one because you're choosing a person that you trust to be in the situation and make good decisions. Another type of advance directive is what we call a living will. That's a document where you can make decisions about your care today that will be implemented later. Usually it's with regard to end-of-life decisions. And finally, another type of advance directive is what is known as a DNR, do not resuscitate order. That means if you're found to be in cardiac arrest, for example, it's your wish to not be revived. Typically, that is done with the assistance of a doctor rather than a lawyer, because it's often viewed as a medical decision that a doctor is better able to advise you on. This concludes the NPERS estate planning presentation of your retirement seminar. I hope you've learned something today. Please don't hesitate to contact me should you have any questions after this presentation. Again, my name is Ramzi Hynek. I'm with Rembolt Ludtke Law Firm, and my email address is rhynek@remboltlawfirm.com. Thank you.